here is one of the more challenging questions that I have had to think about in the AMA yet, and that is getting an HOA board to follow the rules. And the person who submitted this question asked for privacy, or did not ask for privacy, but I did not feel comfortable sharing their name because I see that there's probably going to be a dispute in their future. So can the board be made to pay for attorney's fees? So in Iowa and in many states, HOAs are typically nonprofits and they are typically corporations. And so therefore, the Iowa law for corporations applies to HOA boards. Now, that is not an absolutely true statement. And so ultimately, I have to say there is an "it depends" tacked onto this answer. But oftentimes, an HOA is a nonprofit, and therefore they are subject to Iowa's corporation laws. Iowa, and as far as I know, every state has the idea of a derivative action for corporations. And this is very hardcore geeky stuff, very commonly misunderstood. If you've heard of a derivative action, it might be in a movie like, hostile takeovers and things like that. And so a derivative action is brought by shareholders of a company or those who are an interested party in the company against the board. And it basically says that the company or the organization is being harmed because the board is not doing their job. And derivative actions are almost always ugly litigation matters. And they are brought by, if it's a nonprofit, then members of the nonprofit, or if it's a corporation, then shareholders of the corporation. So this person that said this question is actually on an HOA board, and as a board member, they do not have the ability, the standing is the legal word, to bring this lawsuit. They can only bring a lawsuit if they are a member of the HOA. So I don't own any Ford stock that I know of. Maybe in one of my investments I'm holding some, but I don't own any Ford stock. I therefore cannot bring a derivative action against the Ford board because I have no standing. I'm not affected by their rules. I may not like the rules, but I'm not affected. I can only do it if I'm a shareholder. Likewise, if you are a board member who is not a member, you don't have a house in the Homeowners Association, then you cannot file a derivative action. And so the derivative action causes a court to force the board to do a thing that they should be doing. The winner of the derivative action may be able to collect attorney's fees and other legal fees from the board, from the HOA. So this is kind of a lose-lose situation if you are an HOA member. And so let's just say that your HOA has $2 million set aside, and the HOA board members are not doing what they should, and it's harming the HOA. So the HOA member brings a suit against the board members, wins, and then their legal fees get covered by that $2 million that's in the HOA bank account. So that means that lawsuit harms the members of the HOA because some of that money that was meant to be spent for improvements got eaten up by legal fees. So this is typically done when the actions or inactions by the HOA board or the whatever board are so harmful that spending the money on legal fees is an improvement. So if you need help with a derivative action, please talk to me or some other attorney, and we will help you. For nonprofits, I refer that to a friend. I have someone that I trust to handle nonprofit work. For corporations, I usually am helping the business and not the shareholders, but you should still start a conversation with me. And if I can't help you, I know who can.